A very warm good morning to all of you. My name is Campbell McLachlan. I am Professor of International Distribution, Fellow of Centre, and I have the very pleasant honour of welcoming you back to the third substantive session in this series of Hersch Lauterpacht Lectures in honour and memory of late Karen Knop. This session is on private and foreign relations law, endlessly fascinating triangular relation between public and private international law, and those parts of constitutional law of states particularly concerned with the exercise of the foreign relations power and its effect on private individuals. So my main task this morning is to welcome back to the centre Anna Peters and Roxana Banu. But just before I do that, I cannot fail to take the opportunity to say a few words of my own in relation to Karen Knop, her scholarship meant to me. Because this is, after all, a set of conversations with Karen Knop, and I had a series of conversations that for me were highly productive and enriching which started when I was first writing my own book, Law, a decade ago, on which she then most generously hosted a symposium at the University of Toronto on publication, and then gathered pace when Kurt Bradley organised his All Singing, All Dancing Carnegie Foundation Fund project on comparative foreign relations law, in which I had the pleasure of sitting with Anna in a conference in Tokyo, amongst other places. And then in a second, rather more philosophically searching project on the same set of issues convened by David Deisenhouse on the double-faced constitution at WICO in Berlin. And then finally, although sadly not in person because of the pandemic, in a conference in Helsinki, the beginning conference of what would have been a much larger project on the lost public side of international law, to which I contributed in the depths of the middle of the night from my living room in Wellington, New Zealand. And I then had the honour of serving as one of Karen's referees for her election to be a Max Planck Fellow for the ongoing project. So through all of that, I found that Karen's own scholarship demonstrated both that searching and detailed analysis of the very stuff of law, and I'm thinking in particular, for example, of her great essays on citizenship and on comity, with her strikingly original insights into the relationship between these various otherwise rather disparate bits of or silos in legal thinking about the relations of law beyond the state. Who can, after all, forget that great essay that she wrote back in the year 2000, Here and There, where she observed, quotes, "The domestic interpretation of international law is not simply a conveyor belt that delivers international law to the people." Or the ideas that she floated, which were inspirational to me when I was writing my own book, the ideas that she floated with Ralph Michaels and Annalisa Wright, applying conflict of laws method to questions of the interaction between public law. Through all of this, and as I came to know Karen, the qualities that others have spoken of, the curiosity and her warm collegiality, I benefited from both immensely. Karen, you won't be forgotten. So now I wish to introduce our two speakers who are going to speak this morning on private international law and foreign relations law, and that part of Karen's work. First, Professor Anna Peters, Director of the Max Planck Institute of Comparative Public Law and International Law in Heidelberg, who holds chairs in Heidelberg, the Freie Universität zu Berlin, Basel, and Michigan, who is past president of the European Society and immediate past president of the German Association for International Law, who gave her own Lauterpacht lectures here on the privatization of public international law, who is an associate member of the Institut de Droit International, and whose most recent book, The Individual in International Law, History and Theory was published by Oxford University Press last year. Anna will speak to us on populism, foreign relations law, and global justice. Anna, you are most welcome back to the centre.
Yeah, thank you, Campbell, for the kind words and your memories of Karen and, of course, of the organizers. I'm really very pleased to be here at this occasion. Yes, populist foreign relations law, as Campbell mentioned, was, I think, Karen's last project at the University of Helsinki in 2021, and then was supposed to continue as a Max Planck fellow. Karen and I and Ralf Michels conducted a wonderful week-long summer school in Heidelberg on that topic. You see the Heidelberg Castle in the background. Of course, foreign relations was the term invented by US American scholars, but I agree with Campbell that this body of law, whether you call it Staatsrecht 3, for example, as it is called in Germany, has twin sources, that it is both national and international. And Karen, in her handbook chapter, refers to Campbell's 5 conceptions or 5 functions of foreign international law. In my snapshot of today, and in line with Karen's concerns about populism, especially in its Trumpist form, I will focus on what Campbell called the exclusionary conception. And at the root of this exclusionary conception of foreign relations law lies the old idea that the state exists to protect itself and its citizens from the chaos of the international relations beyond its borders. McLachlan, I hope, writes poems. I quote, "In all times, kings and persons of sovereign authority, because of their independence, are in continual jealousies. And in the state and posture of gladiators, having their weapons pointing and their eyes fixed on one another," end quote, Hobbes. This is, of course, a sorry sign. In my talk today, I will first, under heading A, briefly try to analyze the populist uses of foreign relations law, mainly against international law, and give a preliminary assessment of what's new here today. And then I will examine counter trends, showing that where foreign relations law is used in favor of international law and where international law still seems to be alive and kicking. And then I will speculate where the international legal order might go, and will conclude by giving the last word to Karen. Given the recent events, I will mostly give Trumpist examples. Although Trumpism and the Make America Great Again movement is specific, it has significant populist elements, and a core feature is, of course, the belief that a pure people, either the American nation or the American car worker, has been corrupted by an elite, and that the people's true will needs to be realized in politics. And populists, including Trump, are excellent in performance politics without direct legal content or effect. An example is Trump's renaming of the Gulf of Mexico to Gulf of America. Populists of all shades see especially open borders as a threat on cultural, material, and security grounds, and therefore populists favor closed borders. And depending on the underlying thick ideology, the borders should be closed against foreign people, or against foreign products, or against foreign investors, or against all at once. And the result is a fenced, walled territorial nation state protected by security guards and by tariffs. Of course, building walls is not unlawful per se, but the border measures are typically accompanied by violations, for example, of non-refoulement and human rights, including the prohibition of mass expulsion. But populists also proactively use foreign relations law, for example, for treaty making. An example is the recent Italian-Albanian Treaty on Asylum Centers in Albanian territory, and Italian commentators have analyzed this treaty to be completely useless. Other measures, of course, defunding, like the US cutting of US aid and the defunding of the UNRWA. But most often, populists just exit from international treaties, such as Turkey from the Istanbul Convention in 21, the United States from the Paris Agreement. They also exit from soft law. For example, Trump immediately exited from the OECD global tax deal of 2023. Exit also takes the form of withdrawing from international bodies. For example, the US withdrew from the UN Human Rights Council, and exit from international organizations. In all this, we often see legalistic, even Byzantine uses of the law. For example, the US can walk out from the World Health Organization. Trump did this in the form of an invalidation of the retraction of the first withdrawal from the organization. In the first Trump administration, Trump had in 2020 notified withdrawal of the US from WHO. But new President Biden had in January 21 retracted Trump's notice of withdrawal. So the recent new invalidation of Biden's retraction serves Trump better than a new withdrawal because the period of notice will not start freshly and because the president will not need a new consent of the Senate. Populist leaders of all shades do not like courts. They attack both domestic courts and international courts for the same reason, namely that these are counter-majoritarian institutions. But the facts that judges are not only unelected, but on top, foreign, adds insult to injury in the eyes of populists. Populists can undermine domestic courts, notably by court packing, as elaborately practiced in Poland, Hungary, and the United States. Such court packing is, however, not available as a strategy against international courts and tribunals, and therefore the tactic here is to undermine their credibility and legitimacy. One option is, of course, withdrawal. For example, Bolivia withdrew from ICSID in 2007. The Philippines withdrew from ICC in 2018 because of a prosecution investigation against President Duterte. The new government now arrested and transferred Duterte to the ICC some days ago. This is an illustration of international law not being able to work against politics, but when the political tides change, as in the Philippines, international law can be reactivated. But of course, the ICC can potentially also be simply instrumentalized. Another form of opposition is unlawful non-compliance. For example, Russia, after a constitutional court judgment of 2015, refused, I quote, the Russian Constitutional Court, to follow literally the judgment of the European Court of Human Rights in the event its execution contradicts constitutional values. This was until Russia was expelled in 2022 from the Council of Europe. The third type of backlash against international courts are sanctions by non-member states, so far only against the ICC. Example, of course, the recent US sanctions, asset freeze and entry ban. The Trumpish sanctions against the ICC have been deplored in a statement of 79 of the 125 ICC state parties, and their joint statement says, I quote, "Such measures threaten to erode the international rule of law, but the statement does not condemn them as unlawful." The recent Israeli entry to Israel bill proposes to extend a prohibition on issuing a permit or visa for entering Israel for individuals who support the prosecution of Israeli leaders by the ICC. Of course, entry bans into the country are not lawful under international law. I would like to conclude on courts, saying that not all international courts are equally suspect. Left-wing populists deplore the unelected international arbitrators who decide in favor of foreign investors. Right-wing populists deplore the unelected international human rights court judges who decide in favor of migrants, prisoners, LGBT persons, and so on. And left and right like to use the ICC against the political opponents, for example, prior governments, but they defy the court, the International Criminal Court, when it prosecutes political threats. I now move to the next type of activity, namely just normal violations of international law. Isolated breaches of legal rules, including those of international law, of course, leave the law in place as a matter of as the ICSID and the judgment of 1986 famously pointed out, that even the prohibition on the use of force can be honored in the breach, because the United States had defended its conduct by appealing to exceptions or justifications. The effect was, I quote the ICJ, to confirm rather than to weaken the rule. A current example of such normal violations of international law might be the US disinformation on avian flu that potentially violates WHO international health regulations. Under international law, a lot of conduct is not immediately recognizable as unlawful, but in a gray zone, even for long periods. But where an international body is competent, it can settle such questions and establish a quite clear breach. For example, the ICC has in several cases, beginning with al-Bashir, and then at the occasion of Putin's visit to Mongolia, decided that state parties are obliged to transfer also heads of states of a non-party state because their immunity is not opposable against the international courts. This would also apply to Israeli Prime Minister Netanyahu. Another type of normal violations are typical populist human rights violations, and I would say the probably most violated rights are against discrimination on the basis of race and ethnicity, gender, and sexual orientation. I now move to something which is, I think, different from everyday and normal violations, what Christian Marxen has called systemic opposition. And I think this is what makes the current situation relatively novel. Such systemic opposition is, so to speak, a revolution from the inside. One strategy is the distortion of facts so that they can lead to a wrong legal assessment. Putin's denial of the presence of Russian soldiers in Crimea in the spring of 2014 has become infamous, and the press spoke of little green men. The new US-American stance towards the Russian aggression is not much better. In a press conference of 12 February, Trump said with regard to Ukraine, I quote, "That was not a good war to go into." Of course, not all lying fits under the heading systemic opposition because, of course, in war, it is said the first victim is truth. And small lies are part of our everyday life. However, systematic grand lying on basically every fact that informs political decision-making, ranging from migrants eating cats and dogs to lying with a factor 10 on the US military aid supposedly given to Ukraine, this might amount to a paradigm change. It's a change from the paradigm of good faith endeavors to a paradigm of corruption. And this might have a systemic, a sapping effect also on the international legal order. Second, violations with obviously sham legal explanations can amount to systemic opposition. I would count the US-American tariffs in violation of the United States-Mexico-Canada agreement here. Besides being what the Wall Street Journal called the dumbest trade war in history, Trump's invocation of a national emergency due to opioid influx from Canada obviously doesn't justify the tariffs. This argument does not pass what Tom Frank has established as the laugh test. Similarly, the Russian claims accompanying its aggression in Ukraine also constitute a systemic opposition, especially the principal claim, the assertion that Russia acts in self-defense, is off the mark, because no armed attack against Russia was in sight. The Russian claims have been termed as, I quote, demonstrably rubbish justifications as bullshit. They were mere cynical employment of words to reveal a blatantly unlawful conduct. Because of these obvious flaws of the argumentation, the Russian stance might manifest the state's turn against the existing international legal order. Arguably, Russia has implicitly advocated an international order no longer based on sovereign equality. If accepted, the new order would be a Großraumordnung in the sense of Carl Schmitt's theory of greater space. Initially, both a scholarly and an interstate consensus against Russia's legal claims quickly consolidated. However, the solid state majority condemning the aggression is constantly shrinking. The most recent General Assembly resolution at the occasion of the 3rd anniversary of the Russian invasion, just in February, which calls out the full-scale invasion of Ukraine by the Russian Federation, and the General Assembly is here reaffirming that no territorial acquisition resulting from the threat or use of force shall be recognized as legal. And the General Assembly also calls upon Russia to withdraw its armed forces from territory. But this resolution garnered only 93 plus 65, so 158 pro or abstention. Most shockingly, the US voted against this resolution in the General Assembly. The outcome may well be that Russia's systemic opposition to the international legal order will be crowned with its success. Of course, the lines between an ordinary violation, which might honor the rule and the breach, and systemic opposition can be blurry. It depends on the quality of the purportedly legal justification and on the responses. Now, prominent people here in the room might say that it's impossible to distinguish a proper legal argument from a mere cynical use of an international vocabulary, and I can't resolve this question now. And of course, even capricious legal arguments fulfill a legal job. They confirm that law is the language of states. I'll come back to that later. Therefore, a third type of behavior becomes very important: walking out from the international legal arena. President Trump mainly passes over in silence international law in basically all his moves, announcing to establish a Gaza Riviera without any reference to the international law on self-determination. Similar thing with regard to taking over the Panama Canal and Greenland. In his joint address to Congress of 4th March, Trump said, I quote, on Greenland, and I think we're going to get it. One way or the other, we are going to get it, end of quote, without mentioning non-intervention, sovereignty over natural resources, or self-determination. After the UN Security Council Resolution 2744 of 24th February, with the votes of Russia and the US, I already mentioned it, with the abstention of all European states and no veto by France and the UK, this Security Council resolution does not mention any Russian aggression, but simply speaks of the Russian Federation-Ukraine conflict. The ambassador of Panama in the United States in the UN Security Council rightly stated that this resolution, this silence speaks more eloquently than its words. So what do these pronouncements and actions and silence due to the international legal order as we know it? Commenting on the sanctions against the ICC, the president of the American Society of International Law wrote, I quote, modern international legal order is now under direct assault. Or is it much ado about nothing, as Dira Tladi analyzed Trump administration 1.0? In fact, big powers have always evaded and undermined international law. Oligarchy and hegemony have been perennial features of the international order. Nationalism and protectionism and the lack of solidarity is nothing new. Corporate capture is nothing new. And undemocratic and authoritarian states have been on the rise for more than a decade. So the question is, what's new, if anything? Despite the déjà vu, I see at least three contextual facts that add some new variations to the old song of hegemony. First, the master himself dismantles his house. The current international legal order has been decisively shaped by the US-American lawyers, governments, and academics alike. And the so-called, I quote, unraveling of the American global order has been already well underway for several ways. Science book title of 2020 suggests. But this unraveling had been mainly done by others. The new thing is now that the US itself continues that. Second, relatively new feature of the current constellation is that allies such as Europe and Canada are suddenly on the receiving end. That's new. Third, the current technical and ecological context matters, especially with regard to digital big tech and the planetary challenges we are facing. Nowhere is the reign of capital better illustrated than with the picture of Trump's inauguration. Importantly, the US president can use especially the US dominance in the digital technology against allies and enemies. To conclude, dear Claude, he is right to say that the Trump administration's foreign policy is simply a continuation of US foreign policy on steroids. But these steroids do create new issues. So far, I've only told the story of attacks on international law under the strikes of foreign international law and politics made in the US. But there are often contrary trends, and there is the story of resistance. And Karen was most interested in this storyline and wanted to investigate how actors use foreign relations law as a tool to strengthen international law. First, states sometimes re-accede international organizations or regimes. Of course, US President Biden's re-accession to the Paris Agreement is a famous example. And after Trump's term ends, the US might, under a new president, join again. Ecuador returned to ICSID in 2021 after having quit in 2009. Karen had also planned to investigate the role of domestic courts and parliaments in resisting withdrawal from treaties and international organizations. For example, the South Africa High Court prevented South Africa from denouncing the Rome Statute in 2017, and the Ecuadorian Constitutional Court facilitated Ecuador's return to ICSID in 2021. In a comparative study, the Venice Commission found that there is a trend towards more parliamentary involvement in treaty withdrawal and has applauded this trend, but did not identify a general legal principle in that sense. Another application of international law is, of course, the climate action before domestic courts. Karen had also planned to investigate further the action of international law-friendly cities, applying the Paris Agreement, or harboring undocumented migrants, such as sanctuary cities such as Chicago. And especially in the field of climate action, big transnational corporations are among actors resisting populist backscaling. For example, the European CEO alliance of 8 big companies, including Volkswagen, has publicly urged the EU to stick to the Green Deal. Of course, business action is to some extent a form of blue washing. But pushing for the green transformation also follows the market logic for them. So business can, besides colluding with populist leaders, also contribute to the resilience of international law against populist Europe. The second much noted phenomenon is the rush to international courts, and first of all, the International Court of Justice in what has been called public interest litigation. And examples are, of course, the climate opinions and the various proceedings revolving around allegations of genocide. Plaintiff states like Gambia, South Africa, or Nicaragua are not themselves the victims. They claim to act in the global public interest when invoking erga-omnes norms. But seizing the ICJ may itself be a populist move, for example, by the South African Union Party against Israel, to which it has not forgiven the arms deliveries during the apartheid regime. The lawsuit might also deflect from internal problems with the far right in South Africa, accusing the South African government of a genocide against white farmers. Still, the mere fact that such litigation might have political, even motives, does not necessarily mean that the legal arguments will be frivolous. Such a lawsuit may still contribute to a very welcome clarification and possibly legal development of the law in difficult international legal questions. Further constructive trends, constructive in the sense that they are apt to develop and strengthen international law, are the strategic mobilization of counter norms or counter treaties, to refer to Surabhi's work, and of counter international organizations. These trends are not new. For think of the Asian Infrastructure and Investment Bank, and another example is the WTO multi-party interim appeal arbitration arrangement, concluded by a group of WTO members, including the EU, China, and Brazil. So what to make of both trends and counter trends that I mentioned? I will now try a snapshot on this ongoing shift to border. It's not just stripping off the layers of cooperation, constitutionalization, and global governance back to the international law of coexistence. The most recent developments have overtaken this analysis. The Russian invasion into Ukraine and President Trump's threats of annexing Canada, Greenland, and the Panama Canal, his fantasies about Gaza Riviera, violate or simply discard key principles of the classic international law of coexistence: state sovereignty, territorial integrity, non-use of force, self-determination. We are secondly not reverting to an interstate order of closed sovereign nation states. The states are too entangled through supply chains. They're in economic terms interdependent, and they depend on big business, be it digital tech, resource extractive, or pharmaceutical, as we saw during the pandemic. Civil society actors will continue to organize transnationally and cannot be silenced. Indigenous people are powerfully rising, I would say. The new international legal order will continue to be an order in which non-state actors play a huge role. So this is not a shift back to Westphalia or Eastfalian. Are we heading towards a concert of powers for the global era? This seems unlikely. The vision would be important as an element of soft power. Despite the reappreciation of military hard power, the importance of soft power, the power of ideas and ideologies, can only grow in the age of social media. The discursive power to create a master narrative is all important, as we see with regard to the conflict between Israel and Hamas. Neither Russia, nor the US, nor China alone are able to dominate the rest of the world in this soft power. And due to their lack of a common vision what the global order should look like, they are not concerted, but divided. Finally, the decline of the Western-shaped international legal order is no convincing one. It has not been an entirely Western legal order to begin with, despite the dominance of rich and powerful states, notably Europe and later the US. Many other states, small and peripheral, have constantly contributed legal ideas that are now an integral part of legal order, ranging from state equality to truth, permissions to right of nature. So because international law has never been an entirely Western construct, its potential de-Westernization is maybe less dramatic than it might look at first sight. Secondly, Trump's maneuvers have demonstrated, if anything, a stark divergence not only of interests, but also of normal attitudes among the US and Europe. So overall, it seems more correct to speak with of a divided West instead of a decline of the. So I think the following features seem to be, of course, only in degree, more relevant to characterize the emerging international legal order. The Trumpish obsession with deals is exactly the buzzword for a scheme of horizontal and multiple bilateral arrangement. This is a tripartite move away from vertical institutionalization, so establishment of bodies with authority or some degree of authority over states. Secondly, a move away from multilateralism. And thirdly, and importantly, a move away from cooperation towards a presumed shared and common objective, such as climate mitigation. Of course, this is not entirely new. China has for decades been insisting on bilateral negotiations with its neighbors, as opposed to subjecting its numerous boundary and maritime boundary disputes to arbitration. The visible decline of multilateralism and the so-called stagnation of multilateral treaty making has been an issue for several years now. But I think these prior trends have been dramatically intensified and accelerated under Trump. We should add the renewed confusion between territorial sovereignty and jurisdiction, imperium, and property, dominion, through the revival of the idea of purchase and lease of foreign states' territory, ranging from Greenland to Canada and Canada. Altogether, this might lead to a revival of an international law that formally belongs to the gens of private law, to quote Hersch Lauterpacht here in this room. This is the antithesis of a public international law vested with public authority and enacted in order to pursue the global public interest. However, the private law analogy has a much more bitter taste today than 100 years ago when Lauterpacht examined and even praised it. It smacks of ruthless capitalism and unfettered competition. Although I said that the world will likely not revert to Westphalia or Eastphalia and that the three or rather 2.5 big powers cannot do it alone, this does not preclude inequality from growth. Zelensky himself reminded Trump in the famous encounter of 28th February in the White House that there is a nice big ocean between the US and Europe and Russia. Geographic and maybe also technological spheres of interest are in the process of being carved out. The idea of a new balance of power is floating around, with Trump obviously seeking to drive a wedge between China and Russia, and not unhappy to weaken and divide the European Union. These strategies and approaches do not in themselves change anything in international law, but they have the potential to weaken principles such as the sovereign equality of states, non-intervention, and territorial integrity, because these principles will be bent in order to safeguard the powerful state's interests. Third, the international legal order is becoming less liberal as a shorthand for democracy and market economy, and more authoritarian. Already in 2019, Russian President Vladimir Putin, on the eve of a G20 summit, said that liberalism is obsolete. When President Trump proclaims that he who saves his country does not violate any law, he not only invents an emergency that would warrant exceptional emergency powers, but raises himself above the law and negates the rule of law. As Kim Lane Shepler warned, I quote her, the US is now clearly on an autocratic path paved by law. When the US is becoming an authoritarian regime like other great powers, China and Russia, then this will inevitably strengthen the authoritarian elements in international law, as already sketched out by Tom Ginsburg 5 years ago. To conclude, we are in a relatively new situation, which seems to demand new responses. International law may not be the root cause for the dissatisfaction and resentment to which populism and Trumpism responds. Rather, the current backlash is against enlightenment and modernity itself. Still, international law has functioned as an incubator of populism of all shades, which claims that the elites corrupt the pure people. International law is, of course, elitist. It is literally miles away from the ordinary people. It's unresponsive to their needs, in short, undemocratic. It comes not only from the top, but also from the outside. And that makes it the worst form of governance of all in the eyes of all shades. So the rally for taking back control by Brexiteers and populists, at least in some senses, asks for taking back control from, to use Trump's words, the unaccountable international tribunals, the powerful global bureaucracies, global technocratic elites. But can there be legal responses at all? Of course. Any proposal coming from international legal scholars risks of being perceived by populists and their followers as the confirmation of what they see as, to quote Marty, elite autism of the eggheads, as Trump calls them, us. But because I personally don't have any other tools at hand here, at least not in this setting, I will nevertheless make 3 points. First, recognizing the limits of legal realism. Second, speaking up against tapering out international law. And third, much more anthropological research on living together with strangers. First, although I hate to admit it, the current foreign relations moves of Trump and of other states are well explained by legal realism. Still, this legal realism cannot fully explain all what's happening in the political world. For example, why democracy is on the rise in many African states, or why vegan meals in public institutions are becoming a norm, at least once per thing. So the exclusive realist focus on supposedly fixed and predetermined national interest is especially no reliable guide for conducting sustainable, stable foreign relations, not even right now. Coming back to the UN Security Council resolution 2774, which doesn't mention the Russian aggression, This conveys the message that the category of lawful versus unlawful use of force is not relevant for resolving the conflict. This bestows the Russian aggression with a certain legitimacy. This silence might be useful for creating peace and order right now, but it will not be a just peace, and therefore it will not, and this is my prediction, will not be sustainable, unless maybe in a later stage, additional steps of transitional justice towards truth, reconciliation, and possibly revolution will be taken. The silence of the Security Council leads to the second point. The checkout from international law, its tapering out, is the most important change for the international legal order as a whole. Danger. Therefore, we must bring as many people as possible to speak about international law and bring in the legal perspective as one of many perspectives in discussions about Gaza or Greenland, tariffs, natural resources. But that's not enough. We all know how international law functions as an ideology, invoked by the hegemon in order to cloak the privilege. But even if that rhetoric is to a large extent a sham disguising the true realities of power, the law, including international law, is not only a disguise of power, but at the same time is also constitutive of power and a check on it, even if only through its discursive entanglement or argumentative self-entrapment. Even international law regularly, or at least occasionally, hamstrings those in power that wish to use the law on their own advantage. Those who, however hypocritically, invoke international law, they still, on a surface level, acknowledge the authority of the prescription. And even the cynic invites other actors to formulate their criticism, also in the form of legal arguments. If not even the claim that the law serves the public good is upheld, however biased or hypocritical that they may be, then there is no reason for citizens or for any other state to obey the law at all. Checking out from international law is even more difficult when also other states fail to place the practice in the context of law, when they do not comment and assess practices against the legal benchmark. Then we have a complete juridification of the international discourse, and then international law will in fact degenerate from the leading normative system for assessing the admissibility of behavior, for example, purchase in Greenland and the Gaza Strip, to one system among others, and it will transform the questions from being also legal questions to purely political questions. And this brings me to what legal scholars can do. My thesis is that the claim that international law is inevitably nothing but ideology, a silk glove that camouflages the iron fist of power, coupled with the suspicion that expert knowledge production inevitably amounts to epidemic violence, makes us international lawyers defenseless against what's just happening. The upcoming new world, without any appeal to international law, however hypocritical these appeals may be, is presumably worse than a world with international law. I fully accept that international law is relatively hollow, but to quote an analysis of the Trump-Zelensky showdown by our Ukrainian colleague Alina Shkaryatova on Verfassungsblog some days ago, when law fails, I therefore suggest more legal anthropological research on aggressive masculinity and how narcissistic males manipulate the masses and build institutions with the help of institutions such as church, state and church, which shield their crimes and lead the world into ruin. To give Karen the last word, in response to a recent editorial in the Leiden Journal, it's of course not in our power and not our job to, I quote, change the world, but rather to analyze and explain, as Karen writes, the context of diversity and historical inequality within persuasion so evidently must operate, and thereby to communicate through work like Karen's the sense of possibilities what the world can become.
Thank you, Anna, for that very inspiring and wonderful address. It's now my pleasure to introduce the respondent for this morning's session, Dr. Roxana Banu, Associate Professor in the Law Faculty at the University of Oxford and Fellow of Lady Margaret Hall, whose work has been characterized by giving the field of private international law what I at least would characterize as a much needed historical and philosophical shot in the arm through her work on the 19th century perspective on an intellectual history of private international law, which originated in her doctoral work under the supervision of Karen at the University of Toronto, for which she won the Alan Marks Medal for the best graduate thesis and the Strauss Law. And then her subsequent collection, just published by Oxford University Press last year, on the philosophical foundation of private law. Roxana, you're very warmly welcome to the Lauterpacht Centre, and I invite you to speak to us on foreign affairs, self-determination, and private international law.
So thank you so much for that introduction, Campbell. I appreciate it. And thank you very much to the organizers for putting this wonderful event together in the memory of Karen. As you've heard, Karen was the supervisor of my doctoral thesis at the University of Toronto. But I suppose I was especially lucky because by the end of that program, Karen had become almost like a second mother to me. So I'm afraid her passing for me is quite raw still. And so I wouldn't be able to sit here and quite tell you what she meant to me personally and professionally. I think that I wouldn't be able to keep it together for the rest of the talk. So I hope that's okay. But I wanted to say that, especially for the topic of my contribution to these lectures, so a kind of reconstruction of the relationship between foreign affairs, private international, and self-determination, I think the whole academic community is really at a loss for not hearing from her and me not sitting in the audience and hearing what she had to say on the topic. Because like many topics that she would pick up on, and I have to say Karen was by far the most imaginative, most brilliant scholar I ever worked with. But like all topics she would pick up on, this too is quite a bit avant-garde. So the interaction between private international and foreign affairs, perhaps even less so than the interaction between public international and foreign affairs, is really not on the radar of private international scholars, with very few notable exceptions. And of course, Cambridge's very own Professor Campbell McLachlan is one of them. But this is really not on the radar of private international scholarship. And I suppose on the assumption that private international only gets going when states are really that they're on the scene, the interaction with foreign affairs with the self-determination questions is even more perplexing. So if you bring these three themes together, that is something that private international scholarship really hasn't picked up on quite, not at all, I would say. So it would have been incredible to hear from her what she would have to say. But I suppose this morning I want to try to respond to the challenge that Karen left for the field of private international law. She had a very strong intuition that the relationship between private international and foreign affairs is much, much stronger than it's thought to be, both by private and public international scholars. So I want to think with her about how we might explain what that connection is, how deeply rooted it might be, and where to recover it. So what I want to suggest is that rather than thinking of it as marginal, perhaps in the edges of the field in questions of sovereign immunity or active state doctrine, and rather than thinking of it as relatively modern, which is, I think, what many scholars would portray it to be, I want to suggest that it is inevitable and that it is a historical constant in the development of private international law. But in order to see that, I think, we need to appreciate four big structural dimensions of the field of private international law. So I'm going to focus on them today a bit. I will also suggest that these four structural dimensions have actually been picked up by Karen in her work on private international law, even though she didn't have the chance to connect them fully to foreign affairs. So in a sense, I hope that the contours of this argument will remind you a bit of her work, but more than anything, remind you of what an incredible contribution Karen brought to the field of private international law and what more work she could have done to make that incredible contribution. Many of you will be familiar with her contribution in public international law, but I think her work in private international law is not given enough credit. Before I talk about these four structural dimensions, which I hope will help convince you that the interaction between these three themes is inevitable, I want to dispel what may be a common assumption about the nature of the field of private international law, and three misconceptions which might fool us into seeing it as a kind of modern development. So in 1926, a year before Eric William Beckett joined the UK Foreign Office as assistant legal advisor, he wrote a piece in the British Yearbook of International Law, revisiting the nature of the field of private international law. And in that piece, he argued that the real test for seeing whether private international law connects to foreign affairs and public international law is whether states could sue one another or complain diplomatically if they fail to comply with universal rules of private international law. And if there were no universal rules of private international law, certainly he didn't think there were any, then there would be no universal obligations for states to hold each other accountable to in private international law. So he suggested we shouldn't be fooled in seeing private international law everywhere and in every topic that has to do with foreigners, and therefore assume that it either responds to or triggers major geopolitical questions. As Beckett himself will discover throughout his tenure at the Foreign Office, and as I'll explain in a minute, that was always bound to be an overly simplistic test. But I think for our purposes, it's interesting that I think that view of the field still has major contemporary resonance. Many scholars might still think of the field as isolated in that way and might still test the interaction of private international and foreign affairs along those same parameters. And I want to ask why. Why is it that we tend to see the interaction between private international and foreign affairs as contingent and at the moment as a kind of trend, as a modern development in the field? I think there are three reasons which Karen's work would push against. One is the assumption that the interaction between private international and foreign affairs is driven by the increased role of human rights norms in the field of private international law, which is, of course, an important development in the field, but it's not exclusively modern. Obviously, as we've heard before, private international, Karen's work in private international law on James Lorimer's Private Citizen of the World, or on domicile as the private side of citizenship, already underscored that private international law has a kind of individual self-determination mode embedded in some of its oldest techniques. So much so, actually, that in 1947, when the Universal Declaration of Human Rights was being drafted, Ben Atkinson Wordley stand before the Grotius Society of International Law and portray private international law as human rights ahead of its time, and in fact be surprised that public international law had just discovered human rights law in 1947, when private international law had been doing it all along. Now, I have argued, and I think this is important, not to idealize private international law's historical humanist variants, but of course, nor should we do that with international human rights law. So my point is not that I would want to recover them and celebrate them fully, but rather to suggest that it may be short-sighted to think that the alignment of private international and foreign affairs somehow started with the international human rights norm. Another assumption is that if it's not this development in human rights law, it's certainly the increased activity of states abroad that might drive a modern trend. And of course, the war on terror brought a new light on the interaction between private international and foreign affairs and generated a tremendous amount of litigation, which I think is well charted in Professor Shaguzi's book. But of course, we think of acts of state abroad as more prevalent nowadays, because in private international in particular, we have virtually no historical memory of the field in the interwar period during the two world wars, and certainly no historical memory of the field in the colonial period. And of course, we need to remind ourselves that some of the contemporary cases are about addressing historical wrongs. Whether it's the brutal repression of the Mau Mau rebellion in Kenya, or of the anti-colonial movement in Cyprus by the UK, or the involvement in the genocide against the Tutsi in Rwanda by the French, and indeed Karen's main focus, sexual enslavement of women, of Korean women. So again, contemporary cases might shed an important new light, but the roots go much deeper than that. And finally, I think the other third assumption that might make the interaction between private international and foreign affairs seem marginal is that many would think that the interpersonal cross-border matters are somehow fundamentally different from the extraterritorial exercise and effect of the public power of states. And I think that was precisely the misconception that Beckett ran on in 1926. But by the time he left the Foreign Office, he had witnessed firsthand how porous the interaction between interstate and interpersonal legal matters could be. So in 1932, he gave a speech before the Grotius Society in which he put on the map just how extensive the operation of states had become in safeguarding their corporations abroad. And a few years later, he had been responsible for the winding down of the mixed courts in Egypt and the Gulf states and tried to reinvent new ways of protecting business interests abroad, either via wholesale incorporation of English codes of law or via private international law. In the same year, 1932, he spearheaded a Chancellor Committee, Lord Chancellor Committee on the laws of marriage and their impact on the nationality of British subjects and foreign subjects, on which, by the way, no women were allowed to sit, despite the fact that the main topic of the committee was the nationality of women in polygamous marriages. What's important, I think, to take from this is that just a few years into Beckett's tenure at the Foreign Office, he found himself arguing that many of the activities of the Foreign Office were literally paralyzed unless one could take some broad-ranging decisions on vast swaths of private international family law matters. So I want to ask, how do we then tap into this kind of historical richness and start seeing private international actually everywhere in foreign affairs, rather than thinking of it as marginal? So now I come to these four themes that I suggested might help us see how deep-ranging the connections are. I should warn you, I'm going to be traveling to multiple contexts, multiple periods, right? Multiple regions. And so it's going to feel a bit like but that's because I'm trying to bring home this idea that it really is everywhere. It's not a contingent historic theme. So the first theme is that private international law actually has its own political theory of the state, which can and often will have very different ramifications from the one in public international law or in constitutional law. Of course, the extent of the differences will vary depending on the history and theory of the field in different jurisdictions. But if we take the UK as an example, the particular political theory of the state and private international law was outlined in Dicey's Law of Domicile in 1879, citing much earlier cases. And in that work, Dicey said we should try to distinguish between the concept of a country in a legal, political, historical sense. And he said, well, neither the geographical nor the historical sense of the word concern writers of law. I suppose he should say shouldn't concern writers of law. That would have been his position, I'm sure. And that the political sense is not useful for private international law, without any justification as to why that may be. So we're left with only the legal sense of the term country, in which a country would be, quote, a district or territory, which, whether it constitutes the whole or a part only of the territory subject to one sovereignty, the whole of the territory subject to one system of law. So while the British Empire was one country in a political sense, it was made up of many different countries in a legal sense. And via a fiction of private international law's own doing, they would be considered foreign in relationship to each other and metropole. Now, in other parts of the world, you might find a similar theory of the state, which might resemble the Namibia exception for those public international scholars in the room. But I think it's important to note that at least in Dicey's formulation and similar articulations, it predates the Namibia exception by quite a bit. And so by that time, when the Namibia exception is fleshed out in public international law, it had produced major legal and political consequences already. For example, the British dominions capitalized on Dicey's theory of the state in private international law to push for their independence in the lead up to the Statute of Westminster in 1921. They started to argue that they actually did have the capacity to legislate with extraterritorial effect, or to conduct their own foreign affairs, because of course Dicey had told them that they are foreign states in relationship to each other and metropole. And that's important because of course the argument wouldn't have been available in public international law or under imperial constitutional law. Later on, designating the Malay states and then the Gulf states as independent states under private international law, even though they weren't independent under public international law because the foreign affairs were conducted by the UK government, had major ramifications and caused quite a lot of confusion in the UK government and abroad about the status of protected states. It was possible, for example, for the Foreign Office, but not for the Colonial Office, to argue that Bahrain was akin to an independent state, because most of the matters which would be thought of as private international law, oil concessions, extraterritorial jurisdiction, trade in pearls and arms, could be seen as foreign affairs. So if we now categorize all the private international law issues as foreign affairs issues, so much is taken out, and so whatever modicum is left for the internal affairs of Bahrain would be enough to characterize it as an independent state, but only under private international. It is clear, therefore, that this alternative theory of the state may often have major ramifications for global affairs and self-determination. So this theory allowed the dominions to discriminate against British subjects of color and the metropole to shield itself from responsibility for abuses in different parts of the country, of the empire, which again were foreign countries. But at the same time, this theory sometimes allows for broader sub-state regional cooperation. In some strange ways, private international law could read cities as legal systems. And so I think in this first structural dimension, private international law is a particularly fruitful terrain for exploring two of Karen's main themes in foreign affairs, namely searching for new understandings of foreign affairs actors and new notions of the state, and increasing grassroots diplomacy at a sub-state level. So I move now to the second structural dimension. Private international law operates with a set of dichotomies that often help to translate foreign affairs questions into private international law cases and may themselves have major geopolitical ramifications. I want to focus briefly on one of them, perhaps the most important of them, which is the distinction between politics and property. The proposition that a state cannot enforce its political laws, now called public laws, not sure if the term is necessarily better, but you get where they feel it moving, in a foreign country, so a state cannot enforce these political public laws in a foreign country, but may make claims to property, like any other individual or corporation. This distinction is often triggered in cases of civil war, secession attempts, revolutions, where states will attempt to sue the revolutionaries and their accomplices abroad, and national courts will have to determine whether those claims imply the prerogative powers of the state or if they're just claims in private law for property. So I want to bring you to one particularly illustrating case on this example. 1861 case, Emperor of Austria v. Day, in which the Emperor of Austria-Hungary sued the British lithographers Day and the Hungarian revolutionary Joseph Kossuth for the seizure of banknotes that Kossuth had commissioned for the lithographers to print with the name Hungary, in case the Hungarian Revolution had been successful. Right, so this was supposed to be there waiting for him to be successful with his Hungarian Revolution. And now the Emperor of Austria-Hungary wanted them seized. Now, the court did indeed grant relief to the emperor and classified this dispute as one of property and not of politics. I don't want to insist on the facts of the case. They're very well illustrated in one of Lord Collins's big lectures. But I want to take a minute to ponder on the geopolitical context of the dispute, which I think the declassified Foreign Office and Home Office show really well. So it turns out a series of correspondence between Joseph Kossuth, and he had a partner, an Italian revolutionary, Giuseppe Mancini. It turns out this correspondence between the two was found, and the Minister of Austria sent it over to the Home Office Secretary and asked the UK to prosecute the revolutionaries for what they were attempting. And so they said, well, perhaps COSID should be under criminal prosecution for the spurious banknotes, as they were called, now bolstered with information about their planned revolution. And the Solicitor General and Attorney General at the time advised the UK government not to start criminal proceedings because the optics for the UK government would have been pretty bad. By then, these revolutions had gathered quite a bit of popularity in both the US and the UK. So the UK didn't want to look as though it was actually undermining self-determination movements. It was better for the emperor to start proceedings in private international and frame the question as a private law property matter than one of politics. In fact, the UK wanted to strengthen Austria-Hungary as a buffer against Russia, but of course not at the expense of looking quite liberal and seeming to encourage the self-determination movements. And so private international law could allow for that ambivalence, right? And my point here is simply to say that it's clear that there was in effect no real separation between the exercise of public power and what we would think of as an interpersonal private international law case. The private international law case could be seen as a kind of covert act of public power. A big geopolitical moment, right, can be captured and hidden in a private international law case. This is my third structural dimension of private international law. Private international law operates under conditions of spatial pluralism, but its methods have been adapted from the context of temporal pluralism, of retroactive laws and state succession. Therefore, the field becomes relevant both in cases of state succession and in navigating legal pluralism in new or newly enlarged states. Karen herself was extremely fascinated by what she called the space-time sequencing of private international law, and this is the aspect she used to think through the case of the Korean comfort women and think about how private international might achieve spatially and temporally limited and contingent closure. In her recent wonderful book on the life and death of states, Natasha Wheatley also picks up on this spatial temporal duality of defining sovereignty after the collapse of Austria-Hungary. But few perhaps would know that this history is actually part and parcel of private international history. The two rival ways of organizing the Austro-Hungarian Empire, and many others, of course, either claiming historic rights to land and pre-existing law, or asserting a plurality of national ethnic group rights, which Wheatley charts as the rival ways of redrawing the map of Europe after World War I, were in fact part private international law creations. And they would have been the field's own contributions to theories of sovereignty, both in an imperial and in a post-imperial context. So in effect, it should be no surprise that the main debates on the legal construction of the new or newly enlarged states after World War I took place primarily in the realm of private international. And I want to give you just three brief examples. In Yugoslavia, debates were centered on the dilemma of portraying a unitary state externally and recognizing the different provinces as independent states internally without a higher level authority to manage their conflict of laws. This was always recognized as a constitutional and foreign affairs dilemma, which was temporarily managed by private international law. Yeah, adjustments were made to solve the conflict between Czech and Slovak law by analogy to private international law through a body of law known as interregional law. Interregional law was, if you will, the main innovation in private international law in Central and Eastern Europe in the first half of the 20th century, but it was otherwise a very common framework for settling conflict of laws in the empire. So now that imperial conflict of laws methodology was repurposed for the post-World War I legal pluralist world in Europe with multiple imperial connotations. In Romania, private international law was a significant point of foreign affairs following this massive enlargement in 1919. Private international scholars were putting forward a theory which they called conflict of laws without conflicts of sovereignty. And this had major geopolitical ramifications. This was Romania's attempt to try to portray itself as a quasi-Western European state because it borrowed from a private international law theory in France known as conflict of laws as conflicts of sovereignty. And on the other hand, it was its attempt to show the world how it could still assert its sovereignty as a unitary state, but at least seem to be respecting minority rights to the minority treaties and vested rights. I could go further to tell you that the drafters of the private international law rules, in fact, argued that one had to take very, very specific standpoints on some of private international law's most technical aspects in order to show the world what kind of state Romania was about to be. The point I'm trying to make with these examples is simply that deploying a particular theory and methodology of private international law was in this context seen as synonymous with developing and asserting a kind of state on the world stage and signaling from the get-go a particular kind of foreign affairs policy. So while we normally think of private international as a post-foundational moment invention, the foundational moment and the creation of private international coincide. And that's really the way in which the state puts itself on the map and explains what foreign policy is going to adopt. The fourth structural dimension is a bit of a slogan, but I suppose we can't emphasize it often enough, which is that the private is political. In one of her last pieces, as we heard yesterday from Marty, Karen argued for the recovery of a lost private side of the history of international law, which she argued, quote, could help us examine transnational everyday life in the imperial center and the capacity of individuals' cross-border legal arrangements to cumulatively reshape their state. Here too, an engagement with the declassified archives of the UK Foreign Office until about 1960 highlights that what Karen called the quotidian international was in fact the quotidian work of the Foreign Affairs Office and the consular departments around the world. When the first legal advisor to the UK Foreign Office, Sir Edward Davidson, was asked to give a sense of the main activities of the Foreign Office, he listed, quote, questions of domicile and status, marriages of British subjects abroad, and conflicts of jurisdiction and of laws as the most important part of the docket of the Foreign Office. And Eric Beckett, whom we've met already, was known to have been, quote, above all devoted to problems of private international, some very difficult specimens of which in the sphere of marriage, divorce, nationality, wills, and so on, constantly arose in the course of the department's legal business in relation to British subjects abroad. So Karen's intuitions about what recovering this history might mean is entirely borne out by these archives. And I'll give you one example. From about 1880 onwards, those offices were most preoccupied with questions of the validity of marriages of the members of the British forces in British occupied territory, some of which were loosely classified as undesirable marriages and subject to some special rules, with the nationality of the children of British subjects in places where the UK exercised extraterritorial privileges, with questions of domicile of what became known as hyphenated subjects, Anglo-Indian, Anglo-Chinese, Anglo-Egyptian, and perhaps above all, with the questions of the impact of polygamous marriages on the nationality of British subjects throughout the formal and informal empire. Different interpretations by the Foreign Office legal advisors of private international law theories and cases often had major ramifications for the activities of the Foreign Office. For example, during Sir Davidson's tenure as legal advisor to the Foreign Office from about 1886 to 1918, he interpreted the main cases of private international law to mean that no polygamous marriages could be recognized for the purpose of granting British nationality to the wives, and that children born from some such marriages were illegitimate. And he had no problem concluding that a child might indeed be legitimate in India under Indian law, and perhaps even a British subject in India. But in England, he's an illegitimate child and a foreigner, if not a stateless. Although the treaty department found the result quote, alarming in that it deprives at one fell swoop all British Indians or other Orientals not born in Her Majesty's dominions of their right to claim British nationality by descent. No statutory enactment or broad-ranging clarifications were thought advisable. Instead, in 1918, Sir Frederick Robertson, judge at the Chief Court of Punjab at the time, decided to give a lecture to the students of the 4 Inns of Court to warn Indian students of attempting to enter into any marriage in England on their own laws. Indian students, of course, pushed against what they saw as blatant discrimination. Why should Englishmen carry their common law on their back when coming to India? But Indians could not bring their personal religious laws with them to England, even when such laws were purportedly recognized in India by the empire. In initiating some of the most difficult private international law cases at the time, actually, Indian students could be seen, as Karen would have seen them, as agents of foreign affairs, pushing the metropole to recognize their religious personal laws and creating a different imaginary of their own state under the empire. So I hope that these 4 themes give you a flavor of just how wide-ranging and historically constant the interaction between private international foreign affairs and self-determination questions might be. But to the extent that you might think, well, if it's not a modern development, it's a historical development, I don't want to leave you in either part of the limbo, right? So now I want to suggest that there are in fact 2 payoffs of trying to put on the scholarly map the inevitable intersection between private international foreign affairs and self-determination. And one of them is that it allows us to see contemporary continuities, historical continuities from the past to the present. And here I connect to some of the contemporary events that Anna is so wonderfully part of in her lecture. I want to give again just a few examples. Private international law theories of the state were used to ponder on the status of the Palestinian territories after the Oslo Accords and will surely be referenced once again. Private international law's time-space sequencing also carries through historically in the current Israel-Palestine conflict. The absentee property legislation, which you might have heard of and which constantly comes back into focus in the conflict, which uses a kind of space-time framework to almost designate a large swath of the Arab population as perpetual enemy aliens. This property can be seized and given to the custodian, is in fact a private international legislation. In the late 40s and 50s, the UK Foreign Office has had to grapple with tens of petitions by British subjects affected by this legislation. And there was an enormous instance of diplomatic engagement between the UK and the US trying to track the repercussions of a complex private international framework of property law for a lot of different issues. It would be really hard to tell you just how rich that archive is. So I'm going to try to chart just a bit of it. So the US and the UK were arguing that this legislation had posed significant geopolitical problems. Why? Well, it would inhibit the chances of Israel being recognized by the Arab states. But the UK and the US clarified that they were not motivated by some kind of humanitarian considerations in posing that problem. Instead, they were worried that if the state of Israel was not going to be recognized, they couldn't secure Israeli support in managing the Suez crisis in alignment with British interests. And they couldn't actually attempt what they wanted to do, which is to secure Gaza for British troops to withdraw from Egypt, and where they could prepare for a potential war with Russia. Instead, in case Russia wanted to exert influence in the Middle East. So you can imagine how this particular property legislation was at the time viewed as the center of a huge geopolitical context. It still is, same legislation and similar geopolitical context, but we've lost track of the historical continuities. Private international scholars are drawing on this alternative theory of the state to think, of course, also about the repercussions for different unrecognized states in the post-Soviet region, and inevitably for the occupied Ukrainian territories. And much of the current legal cooperation on criminal and civil matters between Poland and Ukraine is actually based on the private international law legislation that was passed in Poland after World War I and in Ukraine after its independence from the USSR. Precisely that kind of legislation, I said, coincided with the foundational moment of these states. And of course, the private is undoubtedly still political. As Zeynep Batul-Nakvi shows in her book, colonial narratives continue to inform contemporary perspectives on private international rules on marriages. The war in Ukraine has laid bare the enormous legal, ethical, and political complexities of cross-border surrogacies in times of war, because Ukraine had been the most important destination for reproductive travel worldwide. And the interwar cases involving unaccompanied minors, which were often handled by female social workers under complex private international law frameworks for guardianship and custody, will reappear in the new context of war and populist immigration measures which split families across borders. So that's the first payoff. Perhaps we can become more attuned to contemporary resonances of past events and that kind of historical context. The second, I would argue, is a little bit about broadening the field itself and the material that we engage with in private interaction. So it's interesting that the generation of public international scholars that helped set the foundation of this very center, Clive Perry, Arthur McNair, Ellie Lauterpacht, were keen to appreciate what law officers' opinions, foreign office memoranda, or diplomatic exchanges might show us about the practice of international law. But private international law have never actually developed this preoccupation and have not chartered such material as worthy of study, much less worthy of collection in something like Clive Perry's Digest of International Law, where he looks at the declassified Foreign Office material, or McNair's Law Officers' Opinions on International Law. But I think in failing to engage with such material, the field might have actually closed in on itself and failed to appreciate its own richness and its significance for foreign affairs. Overall, then, I think recovering the history of private international deep enmeshment in foreign affairs can be a continuation of Karen's recovery mode in private international law more broadly. When Karen wrote her piece on citizenship, public and private, she framed her intervention, quote, as restorative rather than radical, because she imagined herself as restoring notions of domicile that were historically deeply entrenched in the field. But she wanted to point out that when recovered in a contemporary context, they may seem surprisingly modern. And so perhaps it is precisely as Karen wrote, quote, in time of war, wide-scale illegal immigration, and stark cultural difference, that we should test whether private international law's hyper-technical techniques can become theory and expand the parameters and the complexity of the thinkable, in the project that she did complete on nationality, and in the project that could have been on contemporary foreign affairs questions. Thank you very much.